Hello, this is Matt on the Moon Lambeau channel. Just this afternoon, Attorney John Deaton publicly stated that he is going to ask Judge Torres to specifically declare that XRP is a non-security. Just to tie everything up in a nice little bow. Now, no guarantee that such a thing will happen. And as many people have been discussing within the XRP community lately, there's nothing in the SEC's motion for summary judgment that says XRP specifically is a security per se. True, but they've also never explicitly stated it. It's just they're speaking out of both sides of their mouth. And Attorney John Deaton was talking about this, so I'm going to let him speak on that topic. I'll show you in full context exactly what he said. And he also said, and this is a quote, that the SEC is sadistically trying to cause panic among XRP holders. That for damn sure is true. That is definitely true. Lots to share with you, but before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Here's a headline from the Daily Hodl. Ripple lawyers should feel confident in XRP lawsuit summary judgment, says crypto legal expert. And to be honest with you, the reason I wanted to run through this because Attorney John Deaton was streaming live, so I guess he called an interview with Fox Business journalist Eleanor Terrett just last night. And it went on for, I want to say, about 50 minutes. I didn't catch it live, but I did end up watching the whole thing. I guess it was technically for me after midnight, so way in the AM hours, whenever it was. But anyway, really fascinating stuff was said, and they transcribed some of it. This is the reason I want to run through this, so check this out. Prominent XRP supporting attorney John Deaton says that Ripple Labs' general counsel has reason to be confident as the company moves to end its lawsuit with the U.S. Securities and Exchange Commission. The SEC sued Ripple Labs in late 2020 under allegations that the payments firm issued XRP as an unregistered security. Ripple Labs recently filed for a summary judgment on the suit, which is when an entity asks the court to dispose of the case without a full trial taking place. Now, Ripple's general counsel, Stuart Alderati, said the following, and this is a quote. "My hot take. After 2 years of litigation, the SEC is unable to identify any contract for investment. That's what the statute requires. And cannot satisfy a single prong of the Supreme Court's Howey test. Everything else is just noise. Congress only gave the SEC jurisdiction over securities. Let's get back to what the law says." End quote. Now, in a new interview with Eleanor Terrett, Deaton says he was surprised by how weak the SEC's filings were, saying that much of their case contained irrelevancies. And by the way, this is what I saw from pretty much, as far as I know, at least all the stuff that I saw from the attorneys within the XRP community. Analysis that I've seen, whether you're talking about Deaton or Hogan or Fred Rispoli or Attorney Bill, from what I've seen anyway, it seems to be pretty strong consensus here that the SEC, based on what is publicly available here, they might be in a little bit of trouble. It's not looking so good, right? But anyway, check out this quote from Attorney Deaton. "I think there's a reason for Stu to be confident. I have to tell you something. I was proven wrong already by these briefs because if people go back to my tweets a couple of weeks ago, I tweeted out that when we see the summary judgment motions and they're unredacted, that we're going to see evidence that we were unaware of. I said I probably predict that there will be some evidence against Ripple that is more damaging than some people think. But it's missing. I was surprised that the SEC did not have more specific evidence. All the specific evidence that they pointed to was to institutional investors and accredited investors. They made no connection to XRP holders, the retail holders, you or me, or people out there," end quote. Yeah, so exactly, and that struck me too. And I shared my initial thoughts the other day. I made a couple of videos just breaking down as best detail as I could as a non-lawyer. And it just struck me that the SEC, they're doing the same thing where it makes it sound like there's something fraudulent going on here. All these accusations of Ripple and executives selling XRP, this and that. Makes it sound like something's going wrong here. But again, obviously there are no fraud claims. And on top of that, the SEC didn't cite any specific contracts or specific sales. And without doing that, what the hell do you have? You're just making broad assertions. You know, like, where were the securities violations specifically? The SEC never says. And we're at the end of the damn lawsuit here. They still haven't said. Isn't that, I don't know, alarming if you're the SEC? I guess they think they can just get away with it. We'll see. Oh, man, it's pretty wild stuff here. But check this out. And this is interesting. So now on this idea that everybody was talking about, including attorney Jeremy Hogan in his most recent video on his very popular YouTube channel, Legal Briefs, one of the things he highlighted was that XRP was not declared by the SEC to be a security per se. But again, just me personally, I didn't even talk about that when I made my videos because they've never said that. In fact, they've explicitly said that they're not claiming XRP as a security. It's just that every time after they say, no, we're not saying XRP is a security, I'm speaking, I'm paraphrasing here basically. Every time they do that, then you look at the rest of what they're saying, and their arguments are such that it's equivalent to them stating that XRP per se is a security. And they're still doing that. They are still doing that, right? So it's like, what do you do with it, you know? So check this out. On that topic here, Attorney John Deaton said the following. I didn't expect the SEC to argue XRP itself as a security per se. They've denied making that argument before, yet argued the functional equivalent within the same paragraph. In the opposition to our intervention, they explicitly denied claiming XRP is a security, but still wrote, and this is a quote, the XRP traded, even in the secondary market, is the embodiment of those facts, circumstances, promises, and expectations, and today represents that investment contract, end quote. So, pause and note here, and we've been saying this forever, though. That's why, again, I personally wasn't surprised that they didn't change after they went down that path, that particular one. Nothing's changed there. So they're still claiming that all of this, the totality of the scheme and the circumstances, that's why. That's the investment contract. Now, I don't think that's a good argument, but I'm just saying that's what they're arguing. And then Deaton says, in the SEC summary judgment brief, they write, quote, the escrow account's purpose was to remind investors of the common enterprise XRP represented, end quote. No, it wasn't. And so it obviously wasn't. It was, what Ripple said is that, and this wasn't the only reason for this, there are other reasons for escrow, but setting that aside for the purpose of this video, it was to ensure a certain release quantity, given that Ripple holds a certain amount, so that you know that only a certain amount in theory could be dumped, even if they sold every, 100% of each escrow, every single month that it released. So that'd be, 1 billion XRP per month. So it's a known quantity. Now that would still be a lot to get dumped on the market if it were fully dumped month after month after month, but it added a bit of additional certainty in theory. And so there you go. So that's the purpose of it. But in terms of that representing a common enterprise, it's obviously completely absurd because, as we've been talking about, there's a difference between common interest and common enterprise. Anyway, Deaton continues. So at first it was today's XRP represents a security because Ripple created the market for it. Now XRP represents the common enterprise. There you go. See how that shifted? These squirrely SEC bastards, I'm telling you. But check this out, and this is the part that I found to be tremendously interesting in this thread, the most interesting in this thread, perhaps. And I don't know I have no idea what to expect from the judge on this, but we going for it. I know we so severely need clarity for XRP. I hope this goes the way that we want it to. But John Deaton says, what we need and what I intend to ask for, doesn't mean we'll get it, is for the judge to declare XRP itself a non-security, just like any other asset or commodity, such as Bitcoin or orange groves or beavers. And then, God, I would love that to happen. Because, look, the good news is, you can't go after XRP specifically, but it would be great to wouldn't it be great to have that extra layer right there? Yeah, it's a non-security. I would absolutely find that to be delightful. And then there is also this from Attorney John Deaton. He says, in the complaint, the SEC claimed Ripple was the common enterprise. Ripple forced it to concede that XRP holders have no legal or financial interest in Ripple, and Ripple owes XRP holders nothing. Because of that concession, the SEC's expert then claimed the common enterprise is the XRP ecosystem. This includes Ripple, all XRP holders in the world, exchanges, developers, users who only hold a minimum XRP to access the XRP ledger, etc. Thus, the common enterprise is everything. And I'll pause to note, and some of you may have seen my video, or maybe somebody else highlighted this specifically, but this is one of my favorite things, is when Ripple's attorneys, in their motion for summary judgment, they pointed out, if you took that logic, which is the SEC's logic, as John Deaton just articulated, everything having to do with XRP is the common enterprise. Apply that to the gold ecosystem. So that would then mean, and I'm kind of paraphrasing here, but you'll get the gist. So that would mean that, miners of gold that's part of the common enterprise. Jewelers are part of the common enterprise. Firms that use gold in microchips for electronic products, they're part of the common enterprise. You just pick it. You can keep on going down that path. So all these firms that are unrelated and in completely different industries doing completely different things with gold, they have a common interest, but that is not a common enterprise, obviously. So when you try to apply this BS logic anywhere else on the planet, you can see how quickly it crumbles and falls apart. It's pretty obvious. Like I always say, any unbiased human with at least half a brain, when presented with the facts, can sniff this out for themselves. Anyway, Attorney John Deaton continues. He says, in the SEC's opposition to our motion to intervene, it argued that XRP represents the investment contract because it is the embodiment of all of Ripple's efforts. In its summary judgment brief, the SEC argues XRP is also a representation of the common enterprise. Yet, in the same breath, the SEC claims it isn't arguing XRP itself is a security, but by arguing that XRP itself represents all of Ripple's efforts and promises, and that XRP represents the common enterprise, it really is arguing XRP itself is the security. Hopefully, non-XRP holders will now see the danger this argument poses, if successful, as it applies to securities laws in general and digital assets specifically. Exactly. And then there was also this. Somebody named XRPL Fawcett wrote to John Deaton, said, John Deaton, you said you would file after reading Ripple's opposition, but this suggests you need to file before then, ? And here's what Attorney John Deaton said. I can't file anything until I read the exhibits attached to the briefs, which are currently sealed. This is the SEC sadistically trying to cause panic among XRP holders who will read this and think it's a significant delay. I have plenty of time and our brief won't cause a delay. I've never seen an agency with such disdain and contempt for the people they are supposed to protect. It's utterly disgusting, and they should be ashamed of themselves. Hell yeah, they should be. They're rat bastards, asshats, completely terrible monsters, sociopaths. The worst that the human species has to offer, frankly. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.